There you go. Yeah, I did, and we were thinking, right, so Ernie and I were just on the reservation, right, and I was like mentally, I'm like, I'm ready for that.
Yeah, there's stuff that-
But I thought you didn't filter something.
All right, I tried to go to the 19. One. It stops at 18. Lots over anything.
Called right back on like, she's amazing, and then I just got into Miami with 1,000 things. So she goes, no, I'm planning both of that today.
No, she's offended.
It's recording, I need to office, so I know you. This is.
The Secretary's office. So she can stay down. Yeah.
I'm sorry. Sorry, it's still used to, so.
All right. Okay.
That makes sense. It's nothing for sure.
So yours all.
Responded.
Like I'm mentioning, the new resolution. So this is the chairman. Most likely they'll pick things in this order. And so here you can see, you know, they're starting. Yeah, and so then,
Because
once we get into like the bulk of all these cases, so they go forward in group consideration, they'll say, okay, these ones were dismissed for service. Do a motion, next. And so those go extremely fast. So I know it looks daunting seeing all of those, but
don't answer.
11 through what, 60 or 70, whatever. 77, yeah, 7 to 6, those go extremely fast. So I would say in total, that portion, 10 minutes maybe? Yeah.
And maybe they're back here that have the people's
Yeah,
name.
the people's names are all attached. I just did them in the order that they're on there.
At this time, 17, I'd like to call the January 18th, 2024 meeting of the Ohio Elections Commission to order. Mr. Richter, will you call the roll, please?
Mr. Carroll.
Present.
Mr. Colkey. Present. Mr. Lyle. Present. Mr. Knight.
Here.
Let's try that again. Ms. Hagan. Yeah, I knew I shouldn't have done all of them first.
Yeah.
Ms. Davis,
Here.
Chair Kaufman.
Here.
Ms. Tavares has an outside engagement that keeps her from today's meeting, so that's why Mr. Colkey is here and Ms. Tavares is not.
Should we make a motion?
I would encourage that, yes.
So. The motion has been made to excuse Vice Chair Tavares. All in favor, signify by saying aye.
Aye.
Opposed, same sign. Motion carries with a vote of 7-0.
The first thing we'd like to do then is swear in Ms. Davis, the newest member of the Ohio Elections Commission. So if you would stand, please. Raise your right hand. Do you swear to support the Constitution of the United States, the Constitution of the State of Ohio, and the laws of the State of Ohio, and faithfully execute the duties of the office of a member of the Ohio Elections Commission as appointed by Governor Mike DeWine for the term designated?
I do.
Thank you very much.
Okay. The first item on the agenda is the approval of the regular meeting minutes of December 14th, 2023. They have been circulated. Do I have a motion?
Come on.
Second.
Okay, I have a motion that's been duly seconded. All in favor, signify by saying aye. Post same sign. Motion carries with a vote of 7-0. Okay. First case in our preliminary review category is case number 2023G-023. Mr. Richter.
The Ohio Auditor State versus Picken. The complainant asserts that the respondent paid for certain campaign item on the credit card of her employer. Putnam County Ag Society, and then improperly reflect the person's any contributions to her campaign.
I'm sorry, improperly, I'm kind of having a hard time.
Okay, I'm sorry. I will tend to do that. I apologize.
Okay.
Improperly reflected the purchases as in-kind contributions to her campaign committee. We did receive a response from counsel for the complainant, essentially denying all the allegations. They asked for a continuance. I talked with counsel for the auditor's office, or traded emails with the auditor's office, and then informed the council that we were planning to go forward to this matter. You can see that my recommendation is to set the matter for hearing. Mr. Smith, on behalf of the auditor's office, is here. If the commission would like to hear further from him as it relates to this matter. If not, commission can act on my recommendation.
Do you wish to hear more?
Yes, please.
All right, well, this matter is related to a criminal case that's pending in Hocking County, Ohio. I'm special prosecutor in that matter, having indicted Commissioner Jessica Dickin for theft as well as election falsification. The theft relates in part to the fact that during the 2022 election on March 22nd, 2022, she placed an order with an entity called 4Imprint for campaign materials used in her campaign for county commissioner, costing $241.59. She paid for them using the Agricultural Society's credit card without their approval. March 25th of that same year, placed an order with Vistaprint for campaign materials used in that same campaign for $190.36. April 20th, she filed a finance report with the Hocking County Board of Elections in which she claimed those expenditures as in-kind contributions for herself to the campaign. On May 6, 2022, she placed an order with Hawks Nest for campaign materials used in that same campaign, costing $3,460, again paid for with the Hocking County Ag Society credit card. And on July 1st, 2022, filed a campaign finance report with the Board of Elections in which she claimed again that this was an in-kind contribution for herself. We've already submitted the records showing the payment by Hocking County Ag Society through their credit card. There was never any reimbursement provided. And we've submitted a statement from Mr. Eddie Ogle, the president, that she never had permission, nor could she have had permission to use public funds of the Ag Society for her campaign. And that's the basis of our position going forward.
Thank you.
Chair, I move the recommendation of the executive director to bring it to a hearing.
Sorry, Madam Chair, I actually have a question. So if I stuff today, if I read Ms. Dickens' motion or for the specific document, but she mentioned there's a court appearance scheduled and recommended it be delayed after that. With other recent things involving, right, situations where something was set for the courts, we waited like up to 2 years. So I guess I'm wondering why in this case we're going forward with a hearing.
Well, first off, it was the request of Mr. Smith to do so. And they did not, well, they did submit that response, but when I told them we were going to go and I was going to recommend setting it for a hearing, they didn't indicate that was a problem for them at this point. Now, maybe it will be when I go about setting the matter. So my inclination is to try and move this forward. My original thought was that Mr. Smith filed this complaint with us in order to get us to make a finding on the issues that are before us and then combine it with the matters that he has brought against the respondent in Hocking County. But it doesn't appear to be the case. So I'm more inclined to try until we get told by the court system to hold off. I'm inclined to try and move this forward and get a resolution.
Or we told by the court system in the previous cases.
Yes.
Okay. Thank you.
Any other questions?
Motion still stands, so.
Correct.
I'll second this, I guess.
Motion.
Okay, we have a motion on the floor that's been duly seconded. All in favor, signify by saying aye.
Aye.
Opposed, same sign. Motion carries with a vote of 7-0. Thank you. The next case is 2023G-017 Gomez versus Girdley.
Thank you, Madam Chair. This is a complaint that asserts the respondent did not include proper disclaimer on certain campaign materials, and that campaign finance reports were not filed with proper office. We've received a variety of responses that I've synopsized for you and I've sent them all out to you. We received an additional response the other day from Mr. Pullins, who is here on behalf of Mr. Girdley. That was circulated to you as well. If you may or may not recall, this matter was before the commission, I think it was December. And then we decided to move it forward. Mr. Pullins indicated that he had some additional information from Mr. Girdley as it related to the response that the treasurer for our Parents' Voice, Carol Fisher, had submitted. So we're back here today. I think Mr. Pullins has submitted those materials. My recommendation stands. I'll leave it at that at this point. Certainly, if the commission would like to hear further from Mr. Pullins on behalf of Mr. Girdley, I informed Mr. Pullins and counsel for the respondent. I'm sorry, not the respondent, counsel for the complainant of what my recommendation was going to be. And I got an email response back from Dennis Lieberman, who was listed as counsel for the complainant, that he agreed with my recommendation and was not going to be appearing today. So Mr. Lieberman is not here, but Mr. Pullins is, and if the commission would like to hear further from Mr. Pullins, it can certainly do so.
Thank you, Madam Chair. So to bring you back where we're at, everything that was alleged primarily in the original complaint from the complainant has been dismissed. Mr. Richter's theory, with all due respect, is based upon the response of the former treasurer 2 years after the fact. What we provided is we provided Mr. Girdley's sworn statement along with text messages between the parties that clearly show that, number one, Mr. Girdley and these other individuals formed a local political action committee. The treasurer was informed there were in-kind contributions and 2 years ago expressed no objections to them. Then, under penalty of elections falsification, she filed the reports with Delaware County correctly, reporting everything. And then the committee was terminated. 2 years later, this complaint was filed. Most of it did not even allege actual violations of Ohio law. Most of it has now been dismissed. What remains is essentially based upon the statements of the respondent. Now, my opinion is if the respondent, the former treasurer, wants to file complaints, she can do so. But you can't base a violation on something that's filed 2 years later by a respondent that contradicts what she filed already. If that makes sense. I know it sounds confusing. The basic issue is they organized the PAC. They made in-kind contributions. They were publicly disclosed, publicly reported. And if there's an issue with reporting at the wrong county, which there's no state law against that, that's something the legislature needs to deal with, not the commission. We would just simply ask that the rest of this complaint be dismissed, and we'll go from there. Are there any questions?
I have one, Madam Chair. Mr. Collins, I believe at our last meeting, correct me if I'm wrong, but I thought you were gonna provide us an email.
I provided text messages.
You know, but you had said at the hearing you had emails going.
I thought they were in the form of emails. I apologize. They were in the form of text messages.
But it was my understanding, it was an email where she digressed, and I didn't see that in text messaging. So.
She digressed.
Well, that basically you're making the point that she was on board with this as opposed to her statement.
That's correct.
And you said you were going to provide us evidence of that.
Yes, I believe we did. You know, it's not 100% clear from the text messages, but you know, if she had an issue with the in-kind contributions 2 years ago, she should have either objected then, which she
I
did,
understand your.
yeah, or not filed them.
Madam Chair, if I could ask the executive director to go into a little bit of detail of how he arrives again. I know you touched on it at the top of his recommendation.
Yeah, well, the complainant, the complaint essentially is asserting that there was an improper disclaimer on certain campaign materials. And then as well, it says campaign finance were filed not with the proper office. I mean, I don't know that that's the case, and that's not what my recommendation for a finding is not on that aspect of the case. It's on the fact that based on the complaint and the responses that we've seen, to me, there was not a proper disclaimer as the statute obligates a person to put on there. And that's the basis for my recommendation. I mean, I certainly in the majority, I don't know that I like to say something like this, but I'll say it anyway. In the majority of cases, a committee is set up in a county, and that's the county in which it acts, and it doesn't necessarily act anywhere else. But in this particular case, it was set up in Delaware County and conduct in, I think it was Montgomery County. That's not the greatest thing in the world, but it is what it is. But the allegations in the complaint, I need to get the file. As I explained in there, recommending the violation because the response from the treasurer in fact says that her intent was to only be involved in Delaware County elections and not for anything in Montgomery County. I feel like there was an improper disclaimer based on what the statute says, 351720 each, which says no candidate or entity shall use or cause to be used a false, fictitious, or fraudulent name or address in the making or issuing of a publication. I think that was not done in this particular circumstance. And so that's the violation that I am recommending that the commission find. And then obviously dismissal of all other allegations contained in the complaint, because there were other statutes that were alleged as it relates to filing and so forth, which I don't see a violation there.
Question to the director as well. So I'm just getting the names right. Miss Fisher is the treasurer, correct?
Correct.
So she says she wasn't aware. Mr. Gergley says she was.
Correct.
So why are we believing one over the other?
Part of it is because, well, first we were provided with the information that we were initially, and we did get a response. Mr. Gergley originally.
We filed a motion to dismiss.
The motion to dismiss, that really didn't get into that. It was at the hearing where it was like, oh, wait a minute, we have these, whether it was emails or text messages, whatever, that she was made aware of all this. Well, I didn't want to influence the commission in any way, and I haven't talked to anybody about it, but I would essentially echo Mr. Lyle's comments. As I'm reading through the materials that were provided, I didn't see anything in there that talked about doing anything aside from having activity in Delaware County. Didn't talk about where they were going to have activity to a certain degree, but you know, her statement is she only understood it to be acting in Delaware County, and that's where she was, and that's what she included in her statement. And I didn't feel like the materials that were included with this statement supported any further knowledge of her in terms of working in a different county. And so I'm more inclined to go along with her statement. It was provided to us first. We were told we would get something else. I didn't think we got something else. And so it's, to me, is why I'm keeping my recommendation as it was.
Thank you, that's all.
Madam Chair, if I could add, she was clearly informed there were in-kind contributions. And if the violation being alleged here is a false disclaimer, it's not which county they were operating in. And the fact is the mailings had the PAC disclaimer, it had a valid address on it. And all this stuff was reported to the Delaware County Board of Elections. Now, that may be proper or not, but that's not what's being alleged here. What's being alleged here is a false disclaimer. And the in-kind contribution was provided to the PAC. The PAC reported it. And the name of the PAC and a valid mailing address was on the mail.
Madam Chair, I have a question. Mr. Pullins, you talked about contradictory statements
Yes,
from Ms. Fisher.
yes.
Could you go over those briefly for me again, just so I fully understand? I'm reading Mr. Gergley's submission.
I mean, essentially, she said that she didn't know about these in-kind contributions and, you know, wouldn't approve, didn't approve of them. And it's clear if you look at Exhibit 2, a series of text messages, there's conversation about money she had raised and postcards that were going to, when she's talking about the mom, she's talking about there were moms that were running for school board.
Okay, but no money for the moms.
Yeah, and he's talking about there'll be some more in-kind contributions. We'll need to file those. There won't be more any dollars coming in. And then she asks, but no money for the moms. And he says, but some of the in-kind contributions will be allocated to those candidates. And I believe there was. And again, it's as an in-kind contribution. And he says, yes, and that's, you know, that's what we have. As I said, she had an objection to that. She should have objected at that time. Or she shouldn't have filed them under penalty of elections falsification. She filed these reports with Delaware saying they're clear and accurate and under penalty of elections falsification. And then 2 years later comes back with an affidavit saying, well, I didn't agree with any of that. I mean, that's clearly contradictory there, besides the text messages we provided.
Thank you.
I just point out Ms. Fisher's statement in the last paragraph. I'm sorry, I had it.
Was that on the Wednesday email, John?
Yeah, it was, but we had gone over this.
Yeah.
This was my point. We had gone over this at the first hearing. And that we had in December, and she says, with encouragement and normal guidance from Mr. Joe Gergley, I created the PAC with the intention of it being a small PAC to help candidates run in Delaware County, specifically school boards. The PAC was used by Hypermetrics without my knowledge to send a mailer for an election to another county. And that was my point. Mr. Pons had stated, at least at the hearing, he was going to provide us an email that she recanted his testimony, and obviously she didn't. I do have text messages, but my understanding is that's what you said at that hearing. You had an email that said she recanted that. In my opinion, she didn't recant. So that's where I'm at. But that's, and that is my belief why we didn't make a decision at the last meeting. It was, we were waiting on that information.
Question, to the director, why $200? There priors here, what?
No, there was not. I just felt that the circumstances, I felt that the circumstances merit in terms of, based on my interpretation of, and taking into consideration Ms. Fisher's response, going beyond, presumably, based on that response, going beyond what the intent of the group was, with Mr. McCurdy doing that, reaching it out to Montgomery County, whereas, according to her, it was supposed to be only in Delaware County. And so I felt that that level of activity was sufficient to, increase the fine a bit from $100.
But, again, just trying to understand the dynamic. It's not against Ohio election law to go multiple counties.
Correct. No.
Thank you.
Madam Chair, I guess my final point would be if you're trying to shoehorn something that is not unlawful into a false disclaimer case. And again, what he did was perfectly lawful, whether it's proper or not, that's something for the legislature to decide. But the disclaimer was not false. The treasurer reported.
Any other questions from commissioners? Okay, hearing none, do we have a motion?
I'll move the executive director's recommendation.
Give a second.
I'll second it.
We have a motion on the floor. It's been duly seconded. Fine and violation against Joseph Gertley, and impose a fine of $200.
Also to dismiss Christian Weekly and Meekly's mailing service and to dismiss Carol Fisher, parents voice back.
Okay, so that is what has been, that's what's on the floor. So all in favor signify by saying aye.
Aye.
Yeah, I can't hear, so, okay. Opposed, same sign.
Nay.
Okay, so the motion
Motion fails.
fails.
3-4.
3-4. Thank you very
Matter will
much.
be dismissed.
Thank you very much.
Thank you. Thank you, Commissioner.
So the next matter for preliminary review is case number 2023D-036 Miller versus Young. So do we have anything with that?
36. David Young is here. He is the respondent. Madam Chair, members of the commission, this is a complaint that asserts the respondent did not include a proper disclaimer on a campaign ad that was posted in the local newspaper. Respondent submitted a response, and as I looked at it, it outlined all of the materials for which claims credit, states that all materials included a proper disclaimer, and apparently, as I looked at it, they did. But the one particular piece that did not include a disclaimer, there was no mention made of it. My recommendation is to find a violation, impose a fine of $50. Certainly, we could hear more from Mr. Young, who is here. Okay.
First of all, I apologize for being here a year
Wait,
late. My letter should have been here
Sir?
January 18, 2023.
Sir, hold on. If you're going to speak, you have to be sworn in.
Please.
You have to be sworn in.
Okay.
Do you swear or affirm that what you're about to say to the commission is the truth, the whole truth, and nothing but the truth?
I'm wrong. Thank you very much.
Thank
I
you.
promise. on the above. So as I said, I'm apologizing for being here a year late. I was supposed to be here January the 18th, 2020, according to my letter that was sent to me. But I understand it could be an oversight. So in regards to my disclaimers, I have a receipt from the paper that I was putting my articles in, as well as my ads. My ads I paid for, my articles I didn't. She said you're contributing to information to the public. So if I put a disclaimer on a article saying I paid for it by, but I didn't pay for it, why do I have to put a disclaimer on it? All of them had one except for one. Call it an oversight, just like this was an oversight telling me to be here a year ago. Understand?
Sure. Anything further?
And that's that part, okay? As far as on my signs, are we discussing that as well, or just the article?
The only thing that was included in the complaint was the one article that did not have a disclaimer.
So even though she sent some pictures of my signs in, that's not a part of the complaint?
Well, no, because they included a disclaimer.
They had a disclaimer, right. So like I said, the one article, there was 4 of them, like 3 of them, did not have a disclaimer on it, because I did say at the end, November 7th, vote for me. That puts me into that category, okay, where I should have a disclaimer. But then again, if she didn't charge me for an article, how can I put a disclaimer paid for by when I didn't pay for it? Have to pay for it.
Thank you. Are there any questions from commissioners?
Madam Chair, if I may. Mr. Young, thank you for being here today. I have some experience in the newspaper business, so I have a couple of questions for you. So is this a paper of general circulation?
It's a small free paper. It's a
Okay.
neighborhood rag, if you want to call it that.
Okay. We don't like to call newspapers rags. Obviously there's a difference in a newspaper between an advertorial and a display ad, a general political ad in which it appears that you had a 1-column block ad that appeared in September that you clearly, I would have assumed, pay for that block
Yes,
ad.
I did, yes, I have the receipt showing such, $65 for 1/8 of a page.
The letter to the community that also that we have, there is remember, this in November, Dave Young, Committee for Young, 3230 Hamilton.
Scipio.
Not even going to try.
Is it an Indian tribe?
So there's that article, and then the other on page 14 that appeared in Community News, the letter to the community that says article submitted by David Young and paid for by Young for trustee. Was this article that you submitted in this particular case in October of 23, did you pay for that ad, or was
I only
it,
paid for ads, not articles.
or I'm sorry, article, you paid,
I did not pay for any
that
article. They were free.
Okay.
That's what I'm saying. How can I put a disclaimer on their paid for by when I wouldn't charge?
Well, I view this very much as a letter to the editor, in a sense. If you paid for the first letter to the community,
No. I never paid for
Right,
any letters,
right.
only articles,
and
which the first one had 2 articles or two ads. The second one, I had 2 half-page ads. The third one, I had 2 half-page ads, and had to take it back 3 half-page ads. But the articles, which were like a quarter of a page or something like that, I did not pay for any article.
so the text, we're going to call it the text column, the guest column, if you will.
Fine, okay.
Did any of your competitors have, were they afforded the same opportunity if they would have walked in,
If they wanted
to
to,
your knowledge?
it's an open forum.
That's where I'm having some problems, Madam Chair and Executive Director. A lot of times, particularly with small community newspapers, you'll have a candidate for trustee or county commissioner or whatever walk in, some column inches to get their word out, whether it be an advertorial or a guest column or a letter to the editor. They're never charged. In most cases. Now, a block ad is different. The display ad is different, in which you very clearly paid for.
Yes, sir.
And so if you are telling this commission that you did not pay for the letter to the community, the guest column, if you will, that appeared in October, even though it says paid for by,
Yes.
the typesetter at the newspaper could have added that in
Well, they
there.
were also taking a little time and trying to block at the end to get it all in one spot. And they dropped a couple of sentences here and there. So my disclaimer could have been, I'm not saying it was or wasn't, could have been, eliminated.
Right. Thank you, Madam Chair.
I guess my question would be, why is it on one but not on the other?
Well, there's not this why on one and why not on, there was 4 articles out, I think 3 articles, take that back, September, October, and November. And I put it out there. Why did I forget to put it on there? I could have. Because the only part, all the other articles I had didn't ask for my vote for me whatsoever. I was just bringing attention to the public. My one article, I will admit, the last 2 sentences and a half was to vote for me. I should have had a disclaimer on that. I had them on the other ones, but wasn't on that. But there again, you put a disclaimer paid for by when you don't pay for it.
I understand what you're saying. I guess I would like to see the other 2. Were provided 2, one that has one and one that does not have a disclaimer. So I guess that was my question as to why one would and why one, another would not. So
Well, consider it an oversight. Just like I'm here late.
Included,
okay.
materials, the complaint only
Yeah.
included 2.
There's you have the one with Exhibit C that has the second block at Ross residents I've been hearing who are the candidates for Ross trustee. So that has a disclaimer.
Yeah.
But if I may, Madam Chair, part of my concern with this is that even though Exhibit C looks like kind of an editorial, it's it's been blocked, which is very common for a newspaper ad to have a margin or a block around it for layout purposes. It distinguishes itself as an ad. The letter to the community, frankly, in my opinion, shouldn't have had a disclaimer on it to begin with. So as long as you didn't pay for it, right? I mean, and to be clear, if the newspaper were giving you display ads, then that would have been an in-kind contribution. If they're a corporation, then that opens up a whole different set of problems for you and for them. But
I have to add, though, realize that what the statute says is issue a form of political publication in support of or opposition to a candidate. Generally speaking, you're talking about advertisements, and that's where you get paid for by. That's also why the commission has not necessarily always strictly enforced the inclusion of the paid for by frame. But here you have materials in which the concluding paragraph says, I also ask you to consider your vote for me, David Young, Ross Township trustee, on November 7th. Thank you. I mean, you may not have paid for it, but it certainly seems like he is issuing a form of political publication in support of his candidacy for office. And that's the reason why I'm recommending what I'm recommending. Certainly you don't have to do a fine amount. I'm recommending a fine, based on, I guess, historically how the commission has recently directed me to. But had that last paragraph not been there, then I would tend to agree with you. It's a letter about the community.
yeah. No, Commissioner, go ahead, please.
Madam Chair, may I ask a question to the director? In regards to sort of freedom of speech and as a candidate, equal airtime, similar notion as a candidate. If you go on a radio show and they ask you, why should we vote for you? And you say X, Y, and Z, and the community is going to be a better place. As so long as they're affording that same airtime to your opposition or anybody in that race, that has been conceivably legal, at least from my understanding in the past. And so I think it similar to what he's considering here, sort of a freedom of speech. And I hear what you're saying on that notion at the end, if you wrap in vote for me, but
That's also, I mean,
Is there?
At least
is there
one
a
say, I would
display
say
where
that.
you can pop up
that,
Or
uh,
on a radio conversation? Is that, I've not seen that, but
And
I
that's
don't
not
know that
really-
it's right
that's
or
not-
wrong.
And I'd say that's not really issuing a, publication at that point, because presumably, you've been invited on the radio station, you're participating in a back and forth. Yeah, maybe they do it to other candidates, et cetera. And I think there's a certain expectation there, and the radio is responsible for that. But again, here you have something that he submitted to the paper. And again, at least as I'm looking at it, if the thing just concludes with, but with slow growth of population and controlled housing areas, we will come through this together. There are 2 levies needed to find the Ross Township Police on the ballot, and the members of the support the funding articles. Okay. Those are community comments that he is making. But there's a different conclusion that I didn't read right there that I talked about before, where he says, I also ask you to consider your vote for me. That I don't know that you can have much more of a political publication.
Yeah.
Expressing your wish to be elected to a position.
Yeah, it's just unique because I don't think that I've ever seen a disclaimer on an opinion piece,
Correct.
ever.
Yeah.
Until
No,
you
I-
submitted
I-
it, so it's just interesting to me, but it is definitely a nuance that
Right.
I respect and understand. With that last statement, it becomes a submission of what seems like a piece for the candidacy, so.
I have a question to the director. Let's say it was a publication, they should have had a disclaimer. It paid for it, clearly. That requires, but he didn't pay for it, right? Like, the committee did not pay for it.
Right.
So. I mean, you put a paid for by, that's clearly inaccurate. So, I mean. What should have been provided free? I mean, is it an in-kind from the newspaper at that point of ad dollars?
A disclaimer doesn't give you that privilege.
Say again?
A disclaimer doesn't give you that privilege. That's saying I didn't have to pay for it. It just says I have to be paid for by.
Paid for by, yeah, I know, but I'm saying,
Right.
so if it. Again, I mean, I don't pretend to be like, the expert on all nuances of the laws here, but, it wasn't paid for by the committee. It feels more like, if anything, an in-kind to the newspaper for an ad block, if it's gonna be considered that, right?
I don't know that I hear what you're saying. I don't know that I'd go that far. What's the value? I mean, then you look back at what's the value of that? Is there a value? Is it de minimis? I mean, because you can't.
So what should be I mean, because it wasn't paid for. His point is valid. It wasn't paid for. by anybody.
I agree
Right.
with you on that point. Sure.
And I mean, it wasn't like he's trying to hide it. He signed his name, right? I mean, so, I guess I have a challenge here. There wasn't an intent to hide. He didn't pay for it. I mean, feels like there's not an appropriate bucket here that this should go into in this situation.
And Madam Chair, may I ask a question of the respondent?
Sure.
Sure, just to clarify, for example, your opposition, they could have walked into that publication and also
He
received.
didn't put anything into the paper whatsoever. He thought he was gonna be a walk-in because he was an incumbent, appointed by an incumbent. He put out only a few signs. Well, he put out 13 signs.
But that's not my
He
question.
could have done
Okay,
that, yes.
Okay. That's,
Other people seeking an election for the school board, so forth, they did. And he didn't.
yeah. Madam Chair, and with respect to the executive director, I do see what you're saying. I just, I don't agree with it. I think, community newspapers serve a purpose. And one of those is relationships with candidates, so that they can go out and get their message out, in an editorial, in a readership style rather than display ads. I'm thinking back to campaigns over the years that, the week before the election, literally there are two double truck, a double truck worth of ads, or I'm sorry, letters to the editor from candidates, from their supporters, from detractors. If we started, disclaiming all of those because they weren't paid for, to your point, I'm just, we're on different tracks here, so. I do respect, I understand where you're coming from, just not there.
Okay.
I just had a comment because and then I respect what I've heard. Maybe this is a question for you. So your October letter that you sent in did have a disclaimer.
Like,
And the November one did not.
I said September and October both had disclaimers on them,
Okay. And then the November one did not.
did not.
So you understood, did you think that actually you needed to include something like that?
I did, whenever I sent it off to her by email, I'd always put a disclaimer on there, which she knew. Did I put it on there? I don't think I did. It would be my fault, my oversight.
So, I actually agree with, I think this is more of an oversight, and I do believe with a lot of the kind of the small newspapers that we have throughout Ohio, I'm more along the lines of getting it right. I don't know if this rises to the level of a fine, but I think just so it doesn't become a ongoing thing in every local little newspaper, especially in this case where they were initially submitted as, paid for by. So I guess I'm leaning more towards kind of finding a violation, but not imposing a fine. Because I think his intent, September, October, was to include it. I do look at this as more of an oversight. So I think that's kind of where I'm at right now.
And Chair, I'll make that motion to not impose a fine, but to find a violation.
We have a second. Motion on the floor that's been duly seconded. All in favor, signify by saying aye. Post same sign.
And
Okay, so. No, I was aye.
You were right. Okay.
So the motion does not pass. The vote of 3-4. Right?
Correct.
Okay. So thank you very much for appearing today.
By the way, they're getting a very sharp edge on the bottom of the shirt when I went to pull it up.
Did you get cut?
Getting it thick.
Yeah, you did get.
Did you get cut?
I guess like, well, no big deal. I'm not gonna drop over the table before I walk out of here. I don't.
But he's.
That's good, I get-
Yeah. In fairness, we're only guessing.
Should I get a disclaimer on that? Not our usual round today.
Normally, we're like never over here in this room.
No.
So.
Trace my blood.
Thank you, sir.
Thank you very much.
My card.
Appreciate it. Okay, the next case before the commission is a preliminary review of case number 2023G-037, Cup versus Cleanup Ida Rupp.
Madam Chair, members of the commission, here the complaint asserts that they responded to not timely filed requisite designation of treasurer or created campaign committee to receive contributions. The deputy treasurer submitted a response that explained the circumstances, essentially talking about the fact that a bank account was established to receive contributions because the library board was not responsive. Subsequently, they did conduct certain campaign activities. They were eventually informed by the board staff of the need to do so, and eventually they did file a designation of treasurer. My recommendation here is to find no violation because of the section that was invoked in 23/1791 applies to candidate campaign committees, not to PAC, which is essentially what this is here. The complainant doesn't appear to be present today. The deputy treasurer, Gregory Fox, is here. If the commission would like to hear, if he would like to say anything further, then you have my recommendation.
Would you like to hear from?
Mr. Fox, If you would be sworn, do you swear or affirm that what you're about to tell the truth is the whole truth and nothing but the truth?
It is.
Thank you very much. Proceed.
So our group, when we became aware of deadlines, filed them immediately. And we found out on the September 28th that we needed to have, we were missing a signature. The Board of Elections called us and said we need to file Form 30D, and we filed that immediately. And then on Friday, September 28th, we were informed that we were missing the signature of the treasurer of our group. So the following week, by Friday, October 6th, that signature was on file. So we tried to be transparent and meet any requirements as soon as we were aware of.
Thank you. Any questions? Hearing none.
No, I don't.
Hearing none, do we have a motion?
I'll move the recommendation of the executive director, final no violation. I'll second.
We have a motion on the floor that's been duly seconded. All in favor, signify by saying aye.
Aye.
Opposed, same sign. Motion carried, vote of 7-0. Thank you for being here today. Okay. The next case is 2023 G-038, Hildebrand versus Sonnenberg. We're saying that correct?
Good morning.
Good morning. Playing it, responding, in
Yep.
case you couldn't see. Wait.
Madam Chair, members of the commission, this is a complaint. The complaint asserts that the respondent uses campaign funds for a variety of personal expenditure in violation of the statutes. The respondent submitted a response. All materials have been circulated to you. It's okay. Respondent first states that he takes responsibility for any and all errors. Goes on to say that all the alleged improper spending has been paid back. There's no present violation. Regardless, the respondent explains the campaign credit card was mistakenly used. You see my recommendation is to find a violation and post $100 fine. Both parties are here. They could be sworn and further address the commission if that's the commission's preference.
Yes.
Okay, we would like to hear from them.
First, Mr. Hildebrand. Sure. Do you swear or affirm that what you're about to say to the commission is the truth, the whole truth, and nothing but the truth?
I affirm, yes.
Okay, please proceed.
Okay, hi, thank you very much. So you have the complaint in front of you. I do want to speak to the fact that Mr. Senator submitted his annual report in January of 2022. January 2023, and in there was a series of 15 charges that occurred, inclusive of other things that were absolutely above board. No concerns with those, but regarding things like spending money at restaurants and gas stations, Progressive Field, we live in Cleveland area, so it's not surprising, and other activities. It was a series of 15 over a 3-month period. And that's the biggest concern that I was noting on him. He did he will note that he filed an amended report in November of 2023. So approximately 10 months later. But you should know that the reason that he filed that was because it was publicly noted earlier in that same month, November 2nd, about these issues. And then that it was only on November 4th when he started writing the checks to reimburse his account, and then filed his amended report on or about November 13th is when it was filed. So the order in that regard.
You would like to speak?
Do you swear or affirm that what you're about to say to the commission is truthful, truth, and nothing but the truth?
I do.
Thank you. Please proceed.
Okay, Mr. Director, Madam Chairwoman, Commissioners, thank you for your time. I obviously did make a mistake, although some of these expenditures probably could fall under legitimate expenses. As far as if I were to go back, I was meeting with constituents and residents, and my board of elections auditor has informed me that those technically could probably qualify as legitimate.
No.
So,
Sorry, ladies.
Was it the,
I was gonna say, so just so you know, I've tried to find Mr. Richter for that in the past. So.
No fine will be issued.
I did disclose and pay back all of the expenditures that were at issue in this case. The truth is that when I filed in January, these expenditures were all made in 2022. They were all inadvertent as far as me accidentally using the campaign credit card, which was in my wallet that I didn't realize was from the campaign, or in one case, at least that I know of, my then 13-year-old son knows where I keep my credit cards, and one night went in, used it to purchase a wig of Trevor Lawrence, who's a football player who has long hair. I didn't realize it till at the end of the year when I did my disclosure statement. And at that point, I did contact my auditor at the Board of Elections, who I'm on good terms with and know, Frank Mazzulli, and said, Frank, I realize upon filing this report that I've made an error. Some of these shouldn't have been put on the card, and I'd like to make that right. He said there was some confusion between him and I. I thought mistakenly that he was going to audit me during the year, and at that point, once he came back with the audit, I would pay back these expenditures. In reality, as it turns out, once I talked to him in November, once this did become public, I said, Frank, not to throw you under the bus, but I was waiting on the audit so I could pay these back. His response is, yeah, I know, but you should have paid it back. But
Do not disturb. I apologize. I do have it on do not disturb.
And he said, you should, obviously you should pay these back now. And of course I did. Literally the next day, November 3rd, I wrote the checks from my personal account to my campaign account to reimburse these. And I did correct the report about a week or two later. And as it stands now, of course, all these expenditures have been paid back and the report's been amended to reflect that. I would say that if the commission were to find a violation, that since I've been filing reports for 7 years and I've had no other issues in the past and I always disclose fully, obviously, I guess in theory, I could have not filed a report upon finding this and nobody would have known that these were at issue. But of course, I did. I'm transparent, and I would ask that if the commission does find a violation, that there be either no fine for good cause shown or a reduced fine from what Mr. Richter has recommended. Thank you very much.
Questions from commissioners?
Madam Chair. Mr. Sandberg, thank you for being here. My question for you, what's the time frame of these purchases and total amount? Can you tell me that? I don't recall.
Yes, I believe the total amount was $349. The wig, I believe, was earlier in the year and January, actually using his complaint, which I don't argue with the facts of it. And the rest were July, August, September, and one in October. I had at some point picked up my card for the campaign, threw it in here's my wallet. It's not the best wallet, it's just simple. And was using it, not realizing that it was a campaign account instead of the other 2 cards that I use.
Yes,
go
ahead.
Sorry, go ahead.
The only comment I guess I would have is, I think once or twice is maybe, to see how many were made in August, I think it just throws it a little bit for me for it just to have been an accident when there were many in August. So, I mean, I see how that happens. I used my HSA card one time and I got in big trouble by my husband, so I never did it again. But I mean, it took one time for me to say, oh, I'm gonna put that in a different section of my water. So, but I understand you can't do that. But I'm just saying that it's disturbing to me how many times it was used just even in August. So, once or twice I get, the other amount is, I think becomes a little excessive, but that's just a comment on my part. So, any other questions from commissioners or?
Chair, if I may. Sir, thank you. Thank you both for being here. Can you tell me what, during my work in campaign world, I would always make sure that I advised candidates that when you do, for example, use your campaign credit card to go to a donut shop, to buy donuts and coffee for a deployment that morning, that you get a receipt, you write exactly what it was for, and even in some cases, who. If it's a private meal with a constituent, for example, or a donor, whatever the case. Um, did you have any internal controls with, obtaining the receipt and then writing the purpose of that meeting on the receipt? So if you were ever audited by the Secretary of State or the Board of Elections, that you would have that proof?
I believe I have at least some receipts. Yes. I don't know if I have them all.
Okay.
I typically don't always keep all receipts I use, and certainly after this episode, I'm a lot more careful and will be going forward in that regard. Yes.
My only comment, and I mean it very respectfully, it's sloppy, in my opinion, that, to go and charge the card, and not keep a really, close record, but mistakes do happen. I concur with you there. So just a comment.
Madam Chair, I guess I'd just like to make a comment in terms of, you stated that you spoke with your auditor and they advised you that a lot of those purchases, you actually could have gone back and made them a part of your campaign contributions, but you just chose not to and are just kind of accepting responsibility for it. Is that correct?
Yeah, he advised me that some of them, of course, if I were to go back, I know for a fact some of them were with constituents. And he said that is legitimate, could be a legitimate campaign expenditure. And my response was, well, look, I'm not going to, I want to be above board and show that, although it was a mistake, shouldn't have happened and maybe sloppy. To the points.
Yeah.
Fair point. I decided I'm not going to, I should pay all of these back and in an abundance of caution and just do the right thing and pay them all back. All of these expenditures for that time period.
And after you were made aware, that is when you paid your campaign account back. Is that correct?
So I was made aware when I went through in January of 23, when I actually because I do my own reports. When I put my report together and went through and did all my expenditures for the year, I said to myself, oh, actually, I made a mistake there. At that point, my auditor and I don't want to say, I guess I self-reported, you could say. I had a conversation with him and said, look, I realized this and I should have probably just repaid it back on the spot. Him and there was a miscommunication. I take full responsibility. I thought he was going to audit me at some point early in 23, and at that point issue some kind of a finding or something, and then I would make the repayment. But at the end of the day, it took that longer period of time for me to do so. But I have, as we sit here today, of course, paid everything back and amended the annual report to show so.
And you were waiting to hear from the auditor at the Board of Elections. The reason why you didn't ratify it right away is in your mind, you were waiting on paperwork, or
I thought he was going to come to me and
just say
something.
Hey, this is what you need.
He, in talking to him subsequent, he kind of said, I don't know that I really said that, Eric. And so either here nor there, but the bottom line is certainly when I filed this report in January 2023, I knew I had made this mistake going back in 22, and I had the conversation with Frank from the Missouli from the County Board of Elections. Yes.
Yes, hi. So thank you, Madam Chair. I would like to note that Mr. Sindenberg is not necessarily providing any evidence that he did have a conversation in January or early 2023 about this aforementioned conversation that he says that did occur. Number two, I want to stress I'm not entirely in alignment that this is a sloppy activity. Instead, it appears when you have you know, when you have one or two, as you noted, these things do occur, and that would not be a legitimate reason for anyone, especially myself, to ever file such a complaint. But when you have repeated attempts over multiple months, it borders to a point on intent, and that maybe was what his goal was, and I don't know what his goal was at that point, but so I just want to make sure that that was clear, those two pieces. So, thank you.
Just to the point about there's no evidence, there's a sworn affidavit that I provided, which is my response to the complaint. It details the conversations I had with Frank. So it is there. If we need to have a further hearing and bring Frank down to Cuyahoga County, I'm sure he would testify to what I've said here today if the commission desires to do so. I hate to drag him out of the board of elections for a whole day, but I'm confident that he would back up what I've said.
Chair, I'm comfortable with the executive director's recommendation.
Have a motion.
It can be if you would like it to be.
Anyone else have any questions or?
I'll second.
Okay. We have a motion on the floor that's been duly seconded. All in favor, signify by saying aye.
Aye.
Opposed, same sign. Motion carries with a vote of 7-0. Thank you very much for coming today. I appreciate your transparency.
I have, sure, because I wanted to make sure I paid this so that there's no issues.
Yes. I'll take it when
Those two gentlemen can remain sitting there.
Your name, Mark.
Yep, Matthew Hildebrand.
Okay, thank you.
The next case, Hildebrand versus the Citizens for Better Beechwood, a complaint asserts the respondent not timely filed the requisite designation of treasurer, circulating campaign materials prior to establishing the PAC. A response was received, which has been circulated to everybody on the complaint. The respondent treasurer states the October 12 letter identified the complaint was not issued or the responsibility of the respondent. Treasurer further states that the complaint failed to show any factual link to the October 12th letter. And the similarities between the letter and the subsequent mailer. Which were the responsibilities or superficial?
Which were the responsibilities?
Which were the responsibility of the respondent? Superficial. With the link. My recommendation is to find a violation. Certainly we can hear further from Mr. Hildebrand. Remind you that you've been sworn. Mr. Sinberg, remind you that you've been sworn as well. Please go ahead, Mr. Hildebrand.
Okay. Yeah, so I want to make sure that we bring this to the attention of the committee. So Mr. Sindenberg organized a PAC, which he absolutely did all the filings on October 17th to note himself as the treasurer. Prior to that PAC organization, and as a result of that PAC, he organized a series of mailings that I believe you have copies of that were these sorts of things. That again, I have a personal conversation, but that is not no legal issues whatsoever. That is fine. The concern is regarding the fact that he did before the organization of that PAC, a letter went out to residents of Beechwood. In addition to that, there were emails that went out, but it was the letter specifically that is of concern. And it went out to a series of residents in Beechwood, and they were mailed, so you have paper envelopes and stamps, and that happened a few weeks at least before the organization of the PAC on October 17th. If you look at a series of the comparisons between the mailer and the letter, there are a lot of consistencies. I'm not going to read those. I know you have it in front of you, but it sure appears that the very same people that were part of the PAC that sent out the mailers subsequent to organizing the PAC were also part of this activity that happened prior to the organization of the PAC. And that is the source of this complaint.
there is sufficient knowledge that at least a inquiry notice should have occurred. I would refer the commission to the exhibits to attach to the complaint by Mr. Barnes. Before I jump there, let me jump back. I have provided to the executive director transcript of proceedings in a court last week, which directly refutes some of the statements made in the response affidavits, which really call in further into question. I'm going to be addressing that shortly. Because I think that is critical if you are looking for the truth. And again, the question is there simply probable cause to proceed forward? It's not a determination of merits. But you look at these exhibits, you have a group of people getting massive emails talking about an organization being formed. Look at Exhibit E, which is the email of July 29th, 2023. Talks about forming this organization and quote, one of the benefits to the 501c4 designation is that donations are not limited and the donor names are not published or reported. That was an email sent to these three candidates. They're on the email chain. And what you're having here is really this massive communication of coordination. You know, these candidates didn't go back and say, hey, if you're doing your own campaign stuff, do it, keep me out of it. Let's keep that Chinese wall put in place. There was no Chinese wall. It's kind of on again, off again matter. Taking excerpts, I didn't want to give the commission a whole 50 page. 13, she just says July 29th email sent to all three responses. He said, this is an email that I sent as an individual to a group of people getting out the vote and the 501 on C4, that is the clock tower. And then finally, 20, she said she's one of the officers, the person testifying, one of the officers of the organization clock tower. At line 12, it says, did there come a time when Clock Tower had a group of candidates running for the Hudson City Council? This is there. She tries to make the distinction. It wasn't the clock tower, it was me individually. I'm throwing a hat on, I'm throwing a hat off. I can't do that. You're gonna keep a separation. You're not gonna have coordination, cooperation, consent between action committee, another organization, and the candidate. You've got to keep that separation. It's not happening. Clock Tower have member candidates. I personally did have a meet and greet at my house, but that was not Clock Tower, that was Jane Howington, Clock Tower. She acknowledged Mr. was at that meet and greet. In fact, all the candidates as well as school board candidates were there. Page 29. When she talks about in the emails about signs are being ordered, et cetera, by page 29, line 23, for clarification, candidate signs were not being ordered by me or Clock Tower, they were being ordered by the individual candidates. And so what you hear is you don't have something where they say the data, there's no coordination, cooperation, consultation, or suggestion, which that meeting in the spring that she makes reference to in the email. They were at that meeting in the spring, and this whole concept of forming this organization, not as a pact. They tell you why they did form it. There's contribution limits in the city of Hudson of $100. They wanted to circumvent that, and they did not want any public disclosure of contributions. They were at the genesis of the formation of this organization. Get these emails. They're all in the emails because they were at that spring meeting. That's coordinated. That's enough at least at this stage of the proceedings. This stage of the proceedings, preliminary. Yeah, there's probably something, maybe something we need a full evidentiary record. So I'm going to ask the commission to find sufficient grounds to proceed forward to a full hearing.
Council for the three respondents who are all here today, sitting, the case may be. First of all, Mr. Harmon did give you a copy of selected pages, transcript, which I guess indicates just now to Mr. Richter. Objecting to this being introduced, evidence cannot be produced in a preliminary review. Every thing he has said, which apparently about 90% of his arguments seem to be based on some trend that he's submitted today. He's stricken his commitment or to see testimony should all be, and this document should not be allowed in the preliminary. So that the I would also note that the transcript is not the full transcript of that hearing.
Would you proceed with your argument?
Yeah, okay. And I will add that I was at that hearing. I was representing Bird at that hearing. The all the testimony, sustained all my objections to every exhibit that attempted to be used that hearing, and the next day issued the judgment dismissing the case. With regard to and the evidence for the commission, one from each of the respondents. Clearly, they were on these two emails that came from Ms. Howington, along with a bunch of other simply included in a group email does not establish that you are part of. It has to be included in Miss Howington. I believe, I think their affidavits indicate, in addition, what is that is in the complaint is these two emails in which my clients, along with a bunch of other people, were included. The allegation that there is a reported in-kind contribution, only relative to a when as an exhibit to the complaint, which was the results of a survey conducted by candidates, and all three of the candidates admit that they received the survey in the mail. They hadn't seen questions. They had no hand in posing the survey, executing the survey, see the survey until they received the survey. Questions. Other surveys, including questions from the Akron Journal attached to their affidavits, responses to the Akron Beacon Journal. The peer from the clock tower Senate and all candidates running for the council, noted when council candidates responded or didn't respond, which is typical with surveys done by newspapers, voters, and lots of organizations. Lots tend to send out survey questions about position on various things. So three candidates also said they didn't, the in-kind contribution to the flyer was then mailed out on the tower that they didn't see until they received it in the mail. And that is what we're here on today. That's all the complaint is alleging, is that that flyer was an in-kind contribution. But there is nothing on candidates to that flyer other than the fact that they're on two emails along with a whole bunch of other people. There's no evidence they ever asked to be included in those emails. Simply being included and even knowing happened, which in this case they didn't know that the flyer was going to happen. But even if they did, that is not coordination, cooperation, said knowledge is not requirement. The requirement is coordination. They have to be taking some action to coordinate. They have to be taking some action to cooperate. They have to do something to give their consent. Or is consult. Okay, there's no evidence that they were consulting. Yeah, there is the only now for two emails. It's not even clear that who is she talking about? And there's a reference in one of the emails that a nonprofit organization is being established, but is asking out Ms. Howington personally. Not the evidence here is compliant. The flyer was coordinated or was consultation to cooperate with the consent. That's the that flyer coordinated contribution time, and the evidence just doesn't exist in the complaint that was filed, and is due in the affidavit signed by all three clients. I would respectfully commission recommendation of the executive.
Now, the evidence is not under you. There's a lot more evidence that goes above and beyond. Yeah. Evidence, statements, even though they may be false or misleading. That's all we're trying to do. To comply. transcript as an attorney, I remember I paid it yesterday from the court reporter. He indicated in that case, which was the case up in some counties where the judge the case, what he did tell you, the judge dismissed it, is she, Ohio jurisdiction of the other. In and so simply being included, or even if they knew, it's like one organization. Now I'm in, now I'm out. My memory serves correctly. There was a campaign a few years before was opposition research, and putting that information and in no coordination with the campaign. They were putting this opposition research on campaigns. Made to internet that nobody knew about. The campaign. I think about I talk about opposition research out on the internet. I send a campaign email and say, I've got opposition research campaign. I said that's not cooperation. That's so is that what we're going to open the door for? Still a lot of actually ones boards political contributing stuff like that. Just start sending a series of emails to the campaign. Open the fine. I'm going to change the way I run campaign to work with super PAC.
Chair, I can have a short rebuttal. True that the judge in Summit County said that the commission had exclusive jurisdiction over campaigns. In that case, it was a contest of the results of the election. The plaintiff in that case, called contest was attempting to argue that that there was an election irregularity and that the election should be thrown out because of the campaign violation. And I argue, no, that's not election irregularity, and the actual results of the election are not being contested. And I think the judge saw that, and that's why the judge dismissed the case. And also, of course, the commission. The commission's over campaign finance limited by statute to the requirements for pay based on privilege, and the commission can need to review the complaint, but is confined to the four corners of the complaint. That is how your jurisdiction is invoked. And in this particular case, the only allegation here is that the candidates received an in-kind contribution from the supplier. All three of them state in paragraph 6 are sent to court or suggest our collaborative the creation of the flyer. The first time I did Exhibit G was when I received it in the mail, and there is no evidence. There's no evidence before you in the was this fire is in coordination in consultation consent. That's the requirement to produce that happen. Simply being included in a group email is not enough. If it is, we could. I could also say there was a lot more complaints about people who are including emails, like maybe anything else on your jurisdiction. Good question. Is
I know, right, but. Well, we did, sent to us. So we was it, we. 613, and we had so many in the. I mean, I things are in. So, my initial chair, either that is burial, hearing, revisiting this again after we've had a chance. I apologize. Here, I got all the day. It's a lot, it's to unpack. So I feel like a job if I go. We just say go on. Trying to sure without comment. To make you watch. You know, just. Oh. You can write it in the.
That if we can get a complaint that we making it 15 to go over it. Well, I'm trying to. Well, I was on the outside.
Next week in DC. I should be back by. But
I mean, if we get something rectified, you know, here, right?
what if I was you? You just said. I read that. Have no problem. That's better. Let's get it from some.
Yeah, it's like, I think that probably. It's interesting. Travel time and. Ladies. But wait, we're not.
It was just for the rest of.
Wow.
Yeah. See rules with them. That's.
So you get. And this.
Yeah.
Time. It's, I am never. 51. And I take a 15-minute recess. Let's take 20 minutes. People can maybe take a break and then what, Mr. So let's meet here at 10. Thank you.
20.
Okay. Nothing. Okay.
Well, we. Yeah, right now, we have to, be, our respect. Reviewing the dollar.
Is.
Certainly here, the statements presented by council. Chair. Yeah. Claim. Right. On your right. Playing. It was collaboration. Artists. So the base. So I've seen it. There was. Just mere, send out those emails and include people. There has to be illustration of, I work with the, I work with the information provided, and provided more just responding. For certain, to everything. So, working materials and those are the kind of elements it's necessary to us that there a big relation there goes to be just responding to a survey here. Texting your I got it. So was discussion about strategy, I could into a little bit more because there's a lot to unpack early. I read, when during discussion, I can't reread, but one of the it wasn't the certain part is Richard talked about, but it's a group of four, they all met and it was a plan. Actually, I'm not repeat your question. Paragraph 3 of the is where first they say each of the respondents had the organization. Initially, like I said, communication preliminary to stop further. Nine paraphrase this organization came in March. 3 to 6 together. They want to form a pact, but they want to be accepted. Was in this case? Yes. That inquiry with the, and we're going to have this on this organization be a pact. And I would also see exhibit F, which is until August 6th. Hasn't. So this organization from meeting 60 people, including the F, as mentioned, spring,
reasonable in this stage of the referring to that mark. We get together for all of you before award can't have you them so they can develop clean practice and want to get out. Yeah, that there might not be enough coordination on the evidence at this stage of the proceeding calls. Let's give discovery and get a full view. I answered. Okay. Statutory. We talked about corners, maybe 5, I'm sorry. You know, but if could you go, one position is on our respect. The position that now we for some knowledge, the fire to a jurisdiction, and service. The complaint, in terms of violation, alleged violation. The, of the, the claim about in-kind contributions, okay, to in, right? So that's why we talk about these, okay? But only in-kind complaint where the with so only in-kind as before you this case, and there is that coordinated the on the plan now, and they they admit they reject the questions. The next thing they get in the mail, apparently, you know, to other households. Okay, that not enough complaints establish and I will argue to be succinct as possible. Coordinate regard the and I mean, I still have to exclude the trend and straight to Lowland County at the beach is properly, but beyond that, if you look at that, I don't think it establishes anything. Okay. That's evidence of some kind of interactions. Is this is from what he candidates who might have fine, okay. Some you read, but it's not about. Okay. Thank you. Could you give us your information? For consent. Yeah.
Mr. Richter, there's two. And state that in action for the.
Oh, evidence not in. Commission for review. Next, which is director, and needs. Commission to allow it. There, the other one, permitted. To be. Under.
Various times. In an effort to try, at least, not try and help you make a decision that's available to permit, and, we may certainly, sure that available. The fact that it's still rejected. Level of but, objections, well, share from a Mr. Richter on fleet. And hours matter. Probable that the continue to less kid. It's not that there is a patient. It's, enough evidence to allow patient. And I don't want to say it moving target, but we agree this, there's not a fast, this. If you look at, to make a fight against could be put 149 components. Yeah, that's what the status variable nature of the probable cause ability that are sufficient to allow.
You have a. It's been duly seconded and they received by.
Yes.
I have 1 o'clock. I gotta get.
Good work. Your grandma and your grandpa.
Well, yes, yeah. I forgot about her.
I'm going to say yes. It's a little bit saying.
It's like our parents.
Oh.
Let's move on to the next page.
For sure. 42. Out of order. Well, we're kind of out of order from the original because I put it together that, as people were kind of, it's all related. is still here for the complaint, Mr. Roper. Ms. Howington is here, as one of the respondents on behalf of the Clock Tower Collaborative. This complaint asserts the respondent to improperly establish a PAC fund as treasurer of the contributions. Respond, it's been out. Most of the allegations, relying advisor to you'll see it was the Supreme Court's decisions in Citizens United indicating that they have the ability to involve themselves in political freedom, not establish a pact. My recommendation is to set the matter for a hearing, similar to the finding of the commission made in one worthy. Certainly the commission. And you can be sworn, but we'll hear first from Mr. Hart on the please.
Thank you, Madam Chair, members of the commission. The question is not whether or not the corporation can make expenditures. The question is, right? The source of its contributions and those expenditures as either a political committee or alternatively as a political contributing committee is a combination of two more purpose nature or primary purpose or oppose any candidate. A political contributing entity means any entity, including the corporation or labor organization that may lawfully make contributions and expend. It's not an individual or a PAC or continuing association, etc. So we're not saying, we're saying it's either a PAC or ECD, one of the two under the statutory definitions. And these actually say here, include the corporation. You look at what's going on, you clearly have two or more persons involved. You have expenditures, you have publications going on, trying to support candidates for public office. Reference on more than deal with, but I would also recognize well-established precedent of this. These type of situations are still there's of course a commission actually found violation and went up, I think, to the 10th district. There was one person, maybe using the colloquial, we do this, we do that. There was a Blake Eastland case from about a year or two ago, which was a law firm alleged to be attacked. The commission found at least probable cause. That got resolved. Counsel on that case resolved it with, and we ended up dismissing it, but there was probable cause for a law firm to function as a PAC. Final thing I would reference on here is the Cincinnati Institute for Jobs, which was a nonprofit corporation. Probable cause to two or more persons basically trying to support or oppose a candidate. So basically, encourage you, in this case, I would encourage you to follow the recommendation of executive director probable cause and set the matter for a full hearing.
Do you swear that do you swear or affirm what you're about to tell the commission is the truth, whole truth?
I do.
Thank you. Proceed.
Well, this I was still over past the last hearing you just had. There was a large group of citizens and I was the city manager for 14 years in Hudson. I know a lot of people have been through that a couple of years ago. Many of the people that I've been in the organization served in Hudson's local government regularly. I do a lot of volunteer work, so I have a lot of opportunity to meet and greet people throughout the community. Over the year of 22 to 2023, I had a lot of people expressing concern with what's going on in government, not just with the city council, but with the school committee as well. Several asked me to run for, I felt that was not, but I did agree that I would convene a group of people that had talked to me over the year, and anybody wanted. It wasn't a secret meeting. And we got together and I just acted as a convener. I said, what do you guys want? What's going on? What are your concerns? Because I wanted everyone there. At that time, Mrs. Gibb was not a candidate. She was a citizen. Madeline was definitely not there. I don't recall if McBird was out. We had a couple hour get together and we had discussions on candidates, and so what came out of it is a majority of that I was here that the need, the last election was less than 23% turnout, voter turnout. And everybody felt that that was one of the priorities. It wasn't who to elect, it was just getting the vote out. So that was one of the primary takeaways that I had from that meeting. Early April, I subsequently met with an attorney, Mr. Hubay, which you may know, and we talked about different types of organizations and decided that a PAC organization was really not going to work because people were more concerned with getting the vote out, not the candidates. I he recommended that I work with an organization called Registered Agents. Registered Agents is an organization that helps you file the paperwork and the reporting work there. So we made sure that we had all of our paperwork correct. We determined there's a lot of fear. And if you go to a whole hearing, we'll be able to produce that evidence, but there's a lot of fear about retaliation in Hudson currently over the last couple of years. And a lot of people were saying they didn't want to have their name on a list of people out of fear of retaliation. One of this decisions to do the advocacy that you don't have to report the people that contribute. So I was really trying to respond to the people that were involved in it. Now, if you go through the complaint, you'll see that we never endorsed candidates. As a Clocktower Collaborative never endorsed candidates. We never made any contributions in kind or other to Clocktower Collaborative to any of the candidates. I have a meet and greet as Jane Havington, as I have the right to do. We didn't need candidates. We all have school board candidates. So again, we weren't limited to just 2 or 3 people. We were whoever was running that we were endorsing. And going back to the only thing we did with not endorsing candidates, that a survey that was a checklist of people would be the easiest thing for the community to hear what everybody's position was. We sent out the canvas to all 8 candidates. And we reminded, an email reminder to all 8. And the survey publication had all 8 candidates' names on it. So again, we were not endorsing any candidate. We were simply saying, here are your city council candidates, and these are the positions that have taken on these matters. The candidates were involved in organizing those. We have a couple of people in town that are newspaper editors for the Cleveland Plain Dealer, and they volunteer to do some writing and editorializing on various citizen committees. Asked them if they could do some articles. We did an article on getting out for August because we had that special election. We did an article on the school levy that was proposed for this, or don't vote for that. It's just a matter of information on the levy. There were 3 people that are named in this. Myself, George, and Bill Woolridge. Those 2 gentlemen are just volunteers. They just help out when they can. We decided we would do a letter November 1st. We have a monthly magazine that comes out. We did a paid letter just saying, these are the Clocktower Collaborative values. And from what we can see, these are values also supported by not only said candidates, we also said candidate school board. That as part of the submittal. At the bottom of that, it didn't say, and vote for these people. It said just, it was not interesting, it was not anything other than voting is the most important thing. The Clock Tower Collaborators and Advocacy Group believes in these values, and we feel these people do too. There's no evidence that they're a PAC. There's no contributions to show that we're a PAC. I have kept earlier hearing. We keep all of the receipts for everything that we spend. I've made $5 since last July. 2 of them were to pay for an advertisement. 1 was a survey. 1 was an educational piece on what to do with write-in ballots, because we had a write ballot, not for any one of these words, but we did have a write. The first times in Hudson that we've ever had. We weren't feeling that there were people that really understood what to do with writing. So we've sent a mailing out for that. Again, it didn't say vote for this or that person. It just said fill in a write-in ballot. So, no, you want to proceed hearing, that's fine, but all of that information will come out that there was no contribution in kind or other, that there is no PAC, that we've continued to be an advocacy organization since November election. We had another full page in the January monthly magazine that again talked about values, what we were going to do in the next, in February, an article on the plan updates. And I'm going to have an article on what's happening since the school levy was approved. Again, these have nothing to do with candidates, the endorsement of any of the people or the income contributions or the others. As a PAC, we just don't have an actual complaint where it says failure to file a nation of treasure. That's for a PAC. We're not a PAC. Failure to file a pre-general report. That's for a PAC. We're not PAC. Failure to file a complete and accurate statement. Once more, it's for a PAC. We are 501c4. I have a professional organization that I pay for to see what reports I need to file and when I need to file the C3 for. Absolutely no.
I'm sure. I would remind in the definition of a PAC, definition of 2 persons, the primary or main purpose of which is to support a candidate, political party or issue, and that it's not a political party, contributing entity, campaign, etc. In terms, I heard and are not endorsing any candidate, never supported candidates. I would refer you to exhibits B and a good complaint of. First, let's start with B is the July 29th email. Right off the bat, we need our ward candidates and identify 1 candidate for each ward and each running an election. Let's meet all the candidates. Let's meet our candidate, the collaboratives. You then on to the second page of exhibit B, that being the July 29th email. It says 1 benefit, this is in the second to last full paragraph on that page from the bottom. The 501c4 designation is that donations are not limited. Why is that important? Because in the city of Hudson, there is a $100 contribution limit to city candidates, including what she described as our candidates. Those 4 candidates have $100 contribution limits for organization, and there are no donations going on. The next paragraph, I know some of the activities that we want to get mailings. What we're hoping to do is some mailings. That's a part of campaigning in support of our ward. They were doing the 4 candidates that we identified. Candidates. If you have to, those information, if you have the capacity to support the collaborative and the mailings, please consider a donation. Last sentence indicates why. These mailings will take some of the off the back of the candidates. Take the back off all candidates running for city council. They took it off the back of our ward candidates. He was reiterating the 4 candidates that they are supporting, that collaborative did support, even though she sat here today and said we didn't support any candidates. Buys the 4 candidates on each ward, doesn't list all the candidates. Please host a meet and greet with your ward candidate. What your ward candidate she gives are our ward candidates. Finally, if you midway in that thing, she actually acknowledges donations to the collaborative are coming in. Donate. We sat here and said there were no contributions to show we were effective. They received money from outside sources. Our ward candidates. There was nothing to say it was a political action committee or it's not a political contributing entity. Either one has to register, have to report the contributions and expenditures, even acknowledges in the email contributions. Thank you.
Madam Chair. The July 29th email was from Jane Howington, jedmhowington@gmail.com. It's my personal email. It was never said in any way that was the Clock Tower Collaborative. Clock Tower Collaborative has their own Gmail account, and the survey that went to all the candidates came from the Clock Tower Collaborative Gmail. There are people in this world that have to wear multiple hats, and we state when we wear one hat or the other. When I say jedmhowington@gmail, that's me. When I work, that's an expression. Our candidates. I have a lot of people that want me to meet and greet or whatever, but it was not with the candidates. It was a Gmail that was to me. This donation that has to do with this. Again, well, the Clock Tower Collaborative, their money was used for mail printing of that did not use candidates that were factual information. No money when you talk about the servant, no money went from the Clock Tower Collaborative to individual candidates. No, when I said money to take the back off of the cost of our candidates, I was correct. Email from some of my supporters that say friends, that say.
Madam Chairman, I'm going to kind of object. I'm trying not to, but we're trying to avoid full hearing. I just read from her comments and I see I just. Oh, that's the last one. And I'm not trying to interrupt her. It's going.
After that July 6th or August 6th, that or we must stay neutral, we must not indicate anything. So I'm just saying, he's alleging things that are just not true.
What we're here to, we've heard your side, we've heard the time I would ask commissioners have questions or either Mr. Hartman.
Madam Chair, the reason why I would name the last just because I did read it on I use the expression in the Sunday doc. I felt that maybe there was support. I agree exactly where I am on this, but I want to hear what I agree with you saying. Has to be comments on anybody off, but
we both actually, library, 5, 1C, 4, correct? So can you both tell me what 1C, 1C donations? Student donations.
Or donations and do receive donations. The primary purpose is as an advocacy organization. They do have the ability to endorse candidates that can't be there for has to be less 50%. And we chose not to do that. But yes, they can endorse.
Yeah, well, generally, yeah, they can receive donations. The question here is not can they receive, but were they a political action committee or alternatively a political contributing entity? Should have filed and report. That's all it is. It's not a question of can they do it. It's a question of you have to report the information and finances.
And this, was there any fires or anything that was produced that tied power that in terms of you said there, donations they had endorsed, looked like they had endorsed candidates. Was there anything that was produced publicly that was to that, so these four candidates or
Yes, it was. I think one, you got the exhibit A, which is, I think, say, hey, here are the candidates that are good. Because again, this goes back to those emails that talk about our. No, look at exhibit A. Did last case. That's part of this, like, to answer your question, I think pointing out it's 4 corners of and the problem cause. Today, that's the complaint. We did get a question, though it's not in the complaint. There was that mailer that was referenced in the previous one. Again, when arching the emails and the meet that tackle or candidate. The other results to express the results to express advocacy. One thing, support. Is this supporting a candidate? I would submit support candidates. There's sufficient evidence, we'll call it based on those emails, that collaborative was support. She wants to say, well, that was me personally, not so well, and me doing that. That's kind of the Corsi case. That is for jobs now. It's like, well, that wasn't me. There this stage of I just comment, you discussed at this stage field, it's like, it's in the case a little bit to me. And move. So, for your question. Which you said, Phil, not necessarily the recommendation, but to see this case where words, clarities, yeah, maybe. But say to you that what I've heard, I would say 1C4, and she's probably done it 1995, correct? In my wording, I think there was and actual meetings, but it was just school boards that they were pushing. So that's what I'm saying. I'm here because I think they're probable cause. But I used to Worthington, similar, but yeah, it's I see what you're saying. But I mean, that Worthington one case, the problem, problems with Worthington.
problems, I think she did. There are a few things this, I don't know. Yeah. And I'm not gonna know that yet. Yeah. Understand that. But I think it's 3 months since, you know, my memory gets a little bad, but.
That one and a website that's just with and it look for this, you know, gotta make its primary purpose. I was doing a good job. Here to that in the appropriate, but it of the well, percent of the activity clear efficacy or percent of principle. And you know, it just we don't really like to me that is a decision.
I'm not in this exact. What we said, are they too very under? We did. I think this is stuff. I'm trying to otherwise make them. I gotta leave this except for here. It's not clear. Would I be thirsty? Oh, it's really.
When we
It's true, that's true.
3 times.
I did. But once you guys have made it up. Here, my.
Has totally like when the.
Reference. I'll send it.
We, correctly. It's a month for a full hearing.
That's correct.
Okay, there's a motion to that. Seconded on the floor, all in favor. Opposing. 7-0. Not being for debate. Have you? We don't know.
I've got to set the commission schedule for the year and you'll get notice of when the matter will go forward. I got one, I mean, spare say. I mean. Don't use. Or. Next. Then I. About.
So we're still in the move forward.
We have two separate. Matter. 3G032 for the educational and 309 scale university, educated by night. They're essentially the same. Different things. Not similar to matter or to what's saying but similar to those person that responded is Michelle Backwoods. You have a team union that has supplied certain advertisements against certain sport candidates. Not properly establishing itself. We responses and motions to this is here on behalf of the respondent in both matters. That's also consolidated I would say it's similar to what we received in the last, but it was rated under that active price organization primary. But my it's just a matter of that we consolidate these for purposes of consideration here and for hearing. The minimum.
With consolidate two, all in favor, signify by saying aye. Aye. Opposed, same sign. Carried to vote at 7.
There will here will be completed. Mr. I've outlined, you guys all copy your Rupert the response of the commission.
Yes, please.
Okay, again, Chair, for bring up for response. I apologize for the cash address. I wrote in really early this morning, so. My first thing I want to say is I wish I'd read this last case because she's the same facts are not quite the same. I found that better with regards to 501c4. 501c4 here. Now, Ohio was serving as mentioned the 501c4 political action committee. Is by law, the IRS, one, I forget what it is, 89 social welfare corporations cannot engage their. You heard my say today should be less than 50%. That's not bad. Most of us in this business use. We use 40% because we never want to get too close. But it's just the reality of this. That's the reality here. This is the fair education organization. For 5 minutes. This policy that you have to see, not that political, and issue education. They asked what reading that and ballot issues. That's what that's. And importantly, in all the activities that this entity has ever done, or impacts in which you deal, give contributions to campus. It never has given contributions to a candidate. You can't give direction. Corporations, bands. So they tend to those common numbers here. So I guess we're to corpus is for interposing political. We don't have that here. Again, it's prohibited by regulations and other regulations. It can't be its primary or major purpose. Chief administrative officer and legal that this activity is organic. And SSH has 100,000 activity plus per year. These cases are in this field. You already reported the way there's nuances of Ohio law as pertaining to the election. It's not political activity. We have a whole advocacy campaign related to election and it's treating the teacher. We worked on the HR regulations. So and on there that have nothing to do with yeah, any to it. And as far as they don't really patients of one violation is here quite often. It's out of hand is not as just tight within the bound. But all people communicate separate these two elections. Contain evidence that the made show hate. I would not coordinate within all of it. There's been no out. Or discussion all you know at tiny and particularly one is and honestly I'm going to authorize I don't think we can't swear instead. So you know I totally like what let me whether it's piece of paper. Federal law, which is here, recognize certain political entities. Qualified. It was these law. This is how this is ever stated are non-connected. No, this is not it. Area committee, which is designated. No, this is not it. For federal committee. No, it's a leadership act. It's a register act. It doesn't qualify. All there is all association and all organization this reference I election into the incorporate all the subpartisan arena as allowed by the court's decision to state that reflects this activity, the appropriate office similar to a Form 30B1 hearing disclosure. Required here no specific report. Quite a while. Actually, you remember, I want to put him on the spot. I had a and asking if there were any application different applications of this law. We engaged activity. Done. Points in our response. At the Secretary of State, we're talking about that specifically communicated to me 2 times. 2014, 2016. When process the designation of meant to establish an Ohio independent. So how does not provided by the Ohio Election Commission. There is no specific registration or for state level in only is an obligation to report. And I understand PC entirely that over or over if you want to be specific, when these are reports, they have a certain number of certain circumstances on a form prescribed state. The Secretary of State's form that could be used to report those in advice issued by the commission. And the tax that qualify about review form apply is the pretty etc. Who has to report form B exactly what these others know that would accept hormone supplies. Go through that. overkill, perhaps it isn't having its just are the requirements in Ohio law. One is the other is talk about 3517B2 specifically exclude from those required for an individual. Other if that's separate program. This is a for social welfare. Revised 5.0 to individuals are involved. Again, you have to be informed, say, hey, there's no room for this. I don't this I think that would work too. So we're anything file records. I think there's an issue to the next own that like it's not showing no email, which I actually direct to the individual. The hey, brand that's by first, which I require all my clients. That be this structure people argue Facebook ads don't require certain circumstances. Facebook ads don't require claim. But Ohio advisory Ohio doesn't buy. You should require them to include it in Educate Ohio Action Fund. Candidate say I made them put them on. They are on there. So there's no be transparent. Like the opportunity for very to find is all there. Raise their rates. And the state teachers. There was no warm here. It's not that they. It's just a different sort of situation here. The bill disclosure, we're following specifically the guidance that was given by this mission and the guidance that's been given by the Ohio Secretary's office. There, there's nothing applies here in Ohio. Are following software having importantly clearly and speak a whole case, whether to be profit for profit or not, have this right to engage in political expenditures, which we offer indication that the entity such as the 501c4 has to First Amendment multiple case law. So I think it's worthy. Not only did they not show here, I think they had they got an approach as to what they left here. They left potential. They did show that the proof had showed that we were being transparent. They not for this for the guns you would want to have. Not a pad, but I think they should face up on the
Any questions?
questions.
I just, that is that Well, obviously, we've had this case, alert type cases in that I, people to other communities. As, you know, we can go forward, but Rupert, my understanding is force this how it's on this because I just say the corporation, you have to actually follow all his file or his organization's file. This came up because I signed an example of we should, the education that we should have before making it. Let's see it.
No, I prefer, I would really prefer formal mode. Okay. Formal, but I mean, who am I? I only have one more meeting. Request anything.
Is we be moving on to the motion to certainly one you could.
Just this set for court hearing.
There is, he did submit that to the government. It's so until I certainly don't get.
Okay. Then second off for. I say. Because. Six.
I say an interesting, real guide, just where the case would be appreciated. About, because I think facts themselves are very gray areas. Somebody, perfect, because really, let's just really. Yeah.
Because one more now. We claim you're a 501. It's not sufficient. Don't get me wrong, okay? We have a foundation, and that goes in that foundation here is that, I mean, 501. Foundation 8 months ago, when, I'll get that case set here. That's fair enough. But that's what I wasn't trying to. I don't know, and I know that, but I mean, that's my recommendation here is making that kind of to do that. Here's what they said. Because in the last case that the court case, that dog county. Said the guy was like, it was all I was doing was I wasn't doing it. So nobody else involved. I can't get back. Well, you know, then it became well, treat help this and help that, and they had a whole bunch of people doing all this other stuff, and they all had, you know, it's like, then all of a sudden, a path. And I don't know that it directly applies to that situation. That could be part of it with political drift.
A great area. Yeah, and I agree that, you know, most people want little, you know.
Let's check out as much as I can. I will say I actually drafted the language that City of Columbus uses for their hearing officers for their campaign finance system. And even though I drafted their request, I said it may be fundamentally unconstitutional for First Amendment purposes. There is a requirement there for independent expenditures, regardless of the type of entity. So it was rewritten. So we do have some precedent in Ohio for that when there's a specific piece of law which says that you do it, whether it's constitutional or not. I say that Okay, so I would probably challenge it myself, is what I told them, so, yeah. Thank you very much for your time.
Good to see you in person. I think last time we saw you on Zoom.
That's right. Yeah, exactly. Thank you, again, I apologize for those two things.
Yeah, I'm really, I really don't want to use this next time. Yeah.
Inclusion was left out, and if you're providing a schedule of when materials are coming out, that's certainly advantage to the candidate. So, you may or may not.
What's
Somebody may or may not.
Yeah.
It's like, no. Why do you know this?
Yes, this is it. I would say, okay, do this.
Let's think it's terrible. I gotta go.
Just, Mr. Hicks is on his way.
Okay.
He'll be here about around 2:30 is his expectation. So I think I kind of saw my text.
Yeah, welcome.
Yeah.
Okay, so we're gonna power through this.
put Mr. Mayview in this. Thank you very much.
Okay, so it is 1:18, so let's power through these other recommendations. So that we can take a short recess, we have people that need to do some really important things, so let's get through this. All right.
That's not the least.
Okay. All right, so the first group, the first cases or the group recommendations, these are to dismiss for failure of service. Their cases, they will be 2023 R dash. They are 113, 116, 118, 132, 133, 142, 172, and 237.
You have made multiple links to these individuals. Areas, going forward, or have you, or vacant, I think vacant. So, my recommendation is to dismiss these failures.
We have a
I'll move the executive director's recommendation.
Duly seconded, all in favor, signify by saying aye. Post same sign, the vote 7-0. The next case is 2023 R-235. The recommendations to dismiss as a community commission. I'm gonna let you talk.
We received from the Butler County Board of Election, and it included an address, but it included an address for a different PAC. And a response from the treasurer for that PAC saying, this PAC is not our PAC. And so we don't have a proper address, so we can't serve. And so my recommendation is to dismiss this.
We have a motion on the floor, just to the second and all in favor, signify by saying aye. Am I not allowed to?
No, sorry. No, that's great. This Kaufman seconded that. I just. Stand for Gino. That's. Okay, sure.
They got to be resting on the laurels. We got to sense of you.
Move second and take the vote, all of these. Boom, boom,
All
boom.
in favor, so do we take the pass by 7-0?
No, take the vote.
Okay,
Aye.
Aye.
all in favor, saying aye. Opposed, motion carried with a vote of 7-0. The next case is 2023 R-180, dismiss the matter, declare the community.
Easier for you to say. I am making this recommendation based on conversation I had with the board of directors, with staff of the Board of Elections, when I talked about this the other day. This is a levy committee. It's been in operation for a number of years. The treasurer, the listed treasurer, they know is from Alabama. The director indicated to me that to the Ridgedale School District, and they thrown up their hands and said, we don't have anything to do with this. Say, no, we're not doing anything with it. And so there's no new treasurer. The treasurer. And the last filing, which I think he said was the 21 annual or most general, there were only $33 left at that point. And so I'm discussing with members, I had a conversation with you, but I'm not going to say you were requesting this. Brian takes motions to dismiss the complaint and to declare the committee terminated. We're reasonably thinking that the bank took whatever monies were left in the account because they spent on monies the same accounts. And so that's my recommendation is to dismiss this matter and declare the commission. Second.
We have a motion that's been duly seconded, all in favor, say aye. Opposed, same. 7-0. The next case, 2023R-261, Mr. Richter.
Even the referral indicated that the submission was submitted at 4:35, I think it was, if you look at the referral, if I look at the referral form. So it was past the 4 p.m. deadline, but while the office of the report was submitted, historically, we have made that a finding of no violation, so that's what I recommend.
I'll second.
We have a motion on the floor. It's been duly seconded. All in favor, signify by saying aye. Signed. Motion carries with a vote of 7-0. The next group of cases is the good cause cases. They are 2023R-188, 2023R-260.
The report was filed, a response was submitted, the explanations included enough that I thought it was worthy of giving a good cause recommendation. The explanations that were provided, I submitted a synopsis of those, and so my recommendation here is to find violation, but for good cause. None of those fine, or we would matter for the prosecution.
Question. Motion. So. Seconded, all in favor, signify by saying aye. Aye. Opposed, sign. Motion carries with a vote of 7-0. Two cases are $50 fine category. They are 2023R-141 and 2023R-254.
Violations, the report had been filed, a response was submitted giving an explanation, the response, submissions were made well beyond week, 10 days. And so my recommendation here is to find a violation and close the fine.
Any questions? Hearing none, we have a motion. So moved. Okay, we have a motion on the floor. Duly seconded, all in favor, signify by saying aye. Aye. Opposed, same sign. No, $7 fine for diesel also for 2023 R-192, 196, 428, 226, and 274.
These are all the first time violated matters that are before us for the first time. No response was submitted, reports have been, and so my recommendation is to find violation, and impose a fine of $100.
And a motion on the floor that's been duly seconded, all in favor, signify by saying aye. Aye. Opposed, same sign. Motion carries with a vote of 7-0. This is in the $250 fine category. It is 2023R-147.
This is a violation for this individual. The first time we imposed a $100 fine. That was paid. Now back again, no response was submitted, but the report was filed about 2 months later. Recommendation is fine violation, imposed fine of 2 months.
Questions of Mr. Richter? For this been voted second. All in favor, saying aye. By saying aye. Opposed, same sign. Carries with a vote of 7-0. Next category is $750 fine category. It is case number 2023R-17.
It's kind of an interesting one. We've never had a case. Fines. We also, I think we're back in the early fine $50. But anyway, what was the board of committee determined in June of this year, the treasurer had resigned or no response to the commission. Felt the $700 fine was an appropriate position based on the history of this community. And so that's the nature of my recommendation of the answer.
Do have a question. Name the individual. Okay, how many?
4. Dave, back. Madam Chair.
The floor that has been first seconded, all of it. Put same sign. The vote. Next case. We will have to.
Well, Davis, would you like to recuse from this matter? You have a relationship, you have at least some sort of relationship with the respondent here. So Ms. Davis is recusing herself from consideration.
Have to leave the room.
Yeah. I
I'm just saying it.
don't think, for this kind of situation, I'm right here.
Okay, so, Mr. Richter.
The no one where there are multiple violations. We would impose fines as well. And so based on circumstances here, I'm recommending we impose a fine of $1,000.
Seconded. All in favor, by saying aye. Aye. Pose same sign. 6 to 0. The next case is a $2,000 fine case. Is 2023 R-258.
Yeah, violations. Have specific fine amount. In the pair, my recommendation, is fine about, and impose fine of $2,000.
Violation.
Or that to 5, 6. And we have imposed, along with imposing per diem fines, we have $100, $200, and $1,000.
Any questions? We have a motion on the floor. It's been delivered. All in favor? Voting sign. Carries with a vote of 7-0. Next group of cases is $25 reconsideration action. They all are 2023 R or 137 666 174 9 0 1 2 2 2 4 0 7 0.
And I will speak to not only these, but the others just in general, because these are all pretty fines where the reports have not been filed. The differences from one case to another matters that have been before the commission. And generally, these are circumstances where have not been before the commission previously, but the reports that would. Again, the differences from one to the next are just a number of cases primarily before the commission. So in this particular, as it relates to for a time person. Really. It is now back again. So I'm glad to answer any questions the commission may ask to through the rest of these recommendations. Though. Director's recommendation.
Motion on the agenda is seconded. All in favor, signify by saying aye. Aye. Pose same sign. Motion carries with a vote of 7-0. Case is 2023 R-106. The recommendation is consolidated case number 2022 R-434. Find a violation, impose a fine of $25 a day with reconsideration. Any questions? Motion on the floor that's been duly seconded. All in favor, signify by saying aye. Same sign. Motion carries with a vote of 7-0. The This is a $25
payment of $250. These cases all begin with 2023 R dash. They are 1126, 164, 175, 198, 232, and 239. Any questions of Mr. Director?
So if they pay, so it's accruing 25 a day and they pay the $250, put it back for reconsideration. Okay.
Do we know? Okay. We have a motion on the floor that's been seconded. All in favor, signify by saying aye. Aye. Pose same sign. Motion carries with a vote of 7-0. Next case is 2023 R-110, recommended $1 a day, $5 a day fine, reconsideration option with payment of $300. We have a question.
So
Motion that's been duly seconded. All in favor, signify by saying aye. Aye. Motion carries with a vote of 7-0. Next case is $25 a day with reconsideration option with payment of $900. That is case number 2023 R-111. Anyone have any questions? Motion on the floor, this is a second. All in favor, signify by saying aye. Opposed, same sign. Motion carries with a vote of 7-0. The next case, the next several cases, the recommendation is to find a violation, impose a fine of $8,705 plus on the reconsideration option. These cases all begin with 2029 R dash. They are 115, 125, 134, 183, and 229. Any questions of the director? Yes. Mr. Director, how did you come up with this fine amount?
That is, these were all failure to file the 2022 and that amount was $25 per day from the date of January 31 until the next day.
Thank you.
Sorry, Commissioner, in the interest of brevity, I do this because I like 8,700, 34,000, I always felt that there needs to be like what's the threshold? Do we turn that over to a prosecutor at some point? Because otherwise, I'm looking for an ally here. So
You may have one.
I would probably, okay. But I'm not going to give the typical spiel because I have a little fatigue going on.
All right.
So that's gonna.
Started.
But I'm here.
Okay, Ms.
Oh, wait. Ooh, ouch. That does hurt. Ooh.
Chair, I apologize.
This is not you. Someone who called me a name earlier. Anyway, Ms. Davis has made a motion to, I know, right? Do we have a second? We have a motion on the floor. That's been duly seconded. All in favor, signify by saying aye. Opposed, same sign. Motion carried with the vote of 7-0. Next case, you will most definitely not appreciate. The next group, there is, Mr. Ricker recommends that we find a violation, impose a fine of $34,900 plus $100 a day. Option. These cases all begin with 2023 R dash. 101, 101, 105, 117, 13, 150, 155, 162, 126, 230. Any question for 2 cases?
Yes, Madam Chair. Mr. Director, can you tell me how you came up with this amount?
Unless I miscalculated, which is certainly a real possibility. 349 days between January 31 and today, $500 is $34,100. And then $1 a day on the future.
To Commissioner Caraway's point, at what point, how far do we go?
Forever. We have done this somewhat repeatedly. Because we'll eventually refer these matters along to the Attorney General's office.
And there are times that we get somebody's attention, which is what the, I guess, approach is intended to do. It's not necessarily getting $34,000 from somebody, but to at least their attention, the same thing for me. If we're fun, you know, then at least the Attorney General just has some of these folks and say, you gotta get your financial report filed. Okay.
And Mr. Point, I'm sorry.
No, in fairness, though, we have millions upon millions of dollars that make no, let's say, no hazard. And it probably would never will be. Sorry, Madam Chair.
I mean, our whole goal is compliance, right? It's not to be a punitive and more, although obviously that's how we function, but compliance is the key. Sometimes if you see something that you're being fined $34,000, it's gonna get your attention, yes, and it's gonna get a response, and then people will figure out, how do I get it fixed? So, yeah, absolutely.
We have a motion, do we have a second? We have a motion on the floor that's been duly seconded. All in favor, signify by saying aye.
Aye.
Pose same sign. The motion vote of 7-0. Okay, 2023 R-1003. The recommendation is find a violation, was fine, but to consolidate with case number 2023 R-023 violation, impose fine of $34,900 plus $100 a day with reconsideration option. So, question. Do we have a motion? Motion to the second, all in favor, signify by saying aye. Opposed, sign. Motion carries with the vote of 7-0. The next three sections are continuations. The first is R-149 is going to be continued for service. Case is 23 R-131 and is going to be continued upon request of the respondent. And the final case is 2021 S-025 will be continued for the rest of the session.
I really need to do that first. Yeah, we got they do this, and all of a sudden, Considering that much better rate. That's got to be my responsibility. I mean, I just. There, you go to the next.